Welcome to The Explainer. Today, we are diving into a really incredible landmark case from South Africa's Constitutional Court. It's CCT 27/99, better known as SV Twala, and we're going to see exactly how one single handwritten letter managed to spark a massive legal debate that made it all the way to the absolute highest court in the land. Okay, let's dive into this. Does every convicted criminal have an absolute right to a full automatic appeal? It's a massive constitutional question, right? Because on the one hand, you've got the absolute necessity of fairness and protecting human rights. But then on the other hand, you have the practical, everyday reality of keeping our judicial system actually functional. So where exactly does the law draw the line? Here's our roadmap for today's explainer. First, Mr. Twala's dilemma. Second, the right to appeal. Third, a constitutional word game. Fourth, the meaning of review. And finally, the final verdict. We'll trace that handwritten letter all the way to a definitive ruling. Part 1. Mr. Twala's Dilemma. Our story starts with a man named J.M. Twala. Back in February of 1998, he was convicted of murder by Cameron J. in the Watersrand High Court. And after his conviction, well, his applications to appeal were totally denied. Frustrated, out of money, and feeling like the system had completely shut him out, he decided to take matters into his own hands. On March 12, 1999, he wrote a handwritten letter directly to the Constitutional Court. He argued that his right to appeal was being unfairly and arbitrarily denied. So the crucial point is the massive legal hurdle standing in Mr. Twala's way. It's this concept called leave to appeal. Under Sections 316 and 315(4) of the Criminal Procedure Act of 1977, an appeal against a high court conviction just isn't automatic. You can't just demand a second trial. You actually have to ask the court for permission or leave. And to get that, you have to prove you have a reasonable prospect of success. Mr. Twala, unfortunately for him, failed to get that permission. Moving on to Section 2, the right to appeal. Let's zoom out to the macro level here. South Africa's final constitution, the one that came into operation in 1997, is actually very clear about the rights of the accused. Section 35, subsection 3, paragraph O, guarantees the right to a fair trial, and it explicitly says this includes the right of, quote, appeal to or review by a higher court. Now, think about that for a second. Mr. Twala firmly believed that because the Criminal Procedure Act forced him to ask for leave to appeal and allowed the courts to deny him that leave, it was directly violating this exact specific constitutional protection. This sets up the dueling perspectives of this whole case perfectly. On one side, you have the applicant, Mr. Twala, alongside the South African Human Rights Commission. They demanded a full rehearing, arguing that the Constitution gives every accused person an absolute, unqualified right to that rehearing, totally regardless of their actual prospects of success. But on the flip side, the state argued for a non-technical approach. They basically said the words appeal or review don't legally mandate a full new trial. They just require a fair reassessment of the issues. Let's get into Section 3, a constitutional word game. This is where it becomes a bit of a textual detective story. Now, what's really interesting to look at here is a tiny yet potentially game-changing difference in wording between South Africa's interim constitution and its final constitution. The interim constitution gave an accused the right to have recourse by way of appeal or review. But the final constitution shortened this. It just guaranteed the right of appeal to or review by. Notice what's missing there? The phrase recourse by way of completely vanished. So, I want you to ponder this for a second. Was that just a typo? Mr. Twala's pro bono counsel definitely didn't think so. They argued that dropping those 4 little words fundamentally changed the law. Did omitting recourse by way of prove that the lawmakers specifically intended to create an absolute, unrestricted right to a full appeal? Well, the court gave a very clear answer. Writing for a unanimous constitutional court, Justice Yaqub ruled that this linguistic change was, honestly, totally immaterial. It wasn't some magic loophole. Dropping those words didn't indicate any intention to ascribe a strict technical meaning to appeal and review. It was simply a shift to plain language. All right. Section 4, the meaning of review. Let's look at what a fair review actually looks like in practice. Justice Yaqub delivered this incredibly powerful quote that really grounds the court's reasoning. He said, "The purpose of Section 35(3) read as a whole is to minimize the risk of wrong convictions and the consequent failure of justice." See, the right to appeal isn't just a self-standing thing. It's a piece of a fair trial. The ultimate goal here is preventing miscarriages of justice. And what's super interesting is that this aligns perfectly with international law, like the International Covenant on Civil and Political Rights, which just requires a conviction to be reviewed by a higher tribunal according to law. Let's move to and see how this builds into the actual procedural safeguards in the Criminal Procedure Act. If you want to appeal, step 1, the trial judge assesses your application. If they say no, you aren't just out of luck. Step 2, you can petition the Chief Justice. Step 3, the Chief Justice designates 2 Supreme Court judges to carefully reassess your petition behind closed doors. And hey, if those 2 disagree, a 3rd judge is brought in. So the court pointed out that this leave process itself constitutes a highly robust, thorough reassessment by higher court judges. But we really have to acknowledge a compelling counterargument here. The Human Rights Commission played devil's advocate, arguing that this rigorous multi-step petition process might sound great on paper, but it's fundamentally unfair to the poor. Think about it. Navigating those legal hoops takes serious money and legal expertise. For someone completely out of resources like Mr. Twala, this system could easily feel like an insurmountable wall. The court, however, had a pretty solid rebuttal for this, pointing to an entirely different part of the Constitution. Section 35(3)(g actually guarantees every accused person the right to legal representation at state expense if substantial injustice would result otherwise. So the system does protect the impoverished by providing state-funded lawyers to help them prepare these very petitions. The lack of money shouldn't prevent a fair reassessment, because the state literally steps in to bridge that gap. Which brings us to our final section, Section 5, the final verdict. Let's summarize where the Constitutional Court ultimately landed. The court reached a unanimous conclusion. Let's run through it. First, there is absolutely no material difference in meaning between the interim and final constitutions on this issue. Second, the right to appeal or review requires a fair reassessment of the issues, not an automatic full rehearing on the record. And third, because the leave to appeal provisions provide that fair reassessment, they are fully constitutional. So ultimately, Mr. Twala's application was officially dismissed. And this brilliantly illustrates a core reality of a legal system. As the court noted, it is not in the interests of justice to clog the roll with meritless and vexatious issues. It's a tough pill to swallow, maybe, but the court has to constantly balance the vital rights of the individual with the practical necessity of keeping the higher courts functional. If the courts are just buried under hopeless cases, they won't have the time to help those who actually have genuine prospects of success. Which leaves us with a final, pretty provocative question. The system relies on this leave to appeal process to act as a fair filter. But if a full rehearing isn't guaranteed for everyone, how do we ensure the system truly leaves no innocent person behind? It's a delicate, high-stakes balance between judicial efficiency and absolute justice, and one that courts have to navigate every single day. Thanks so much for joining me for this explainer, and keep questioning the systems that shape our world.